San Diego. Thank you. Everyone just got the recording notice. I want to welcome you all to Data Privacy. We have a big group here today, so obviously we have a very timely topic for all of us who are going to have to look at how to deal with this ongoing requirements in the state of California, which is obviously quite a bit. California Privacy Act passed in November 2020, and now we have the California Consumer Privacy Act to add additional protections for our consumers. So a lot going on with the CRPA. So today we are going to cover how the CPRA is going to differ from the original California Consumer Privacy Act, strategies on how to comply, what we can see in the next coming year, tips to stay ahead, especially like to see that one of the changing privacy laws. So today we have Procopio is going to give us a fantastic presentation. We have Elaine Harwell, Senior Counsel and Privacy Officer, who focuses on representing clients in privacy and data matters and litigation as well. And Mallory Jensen, who's the Senior Counsel of Privacy at Wells Fargo, which is fantastic. We'll get both a business and a legal perspective. We do have a chat function. I see that Elaine has already said hello to everyone. So if you have a question, please go ahead and ask in the chat function. I think Mallory and Elaine can both see that, but I can as well. So I can try and help make sure that any questions that are coming from our group today are headed off to Mallory and to Elaine to answer. So with that, I will turn it over to the team and we'll get going from there. So thank you, ladies.
Great. Thank you so much, Catherine. And thanks to the ACC for having us here today. I'm Elaine Harwell, as Catherine introduced me earlier, so I won't spend time doing that. And yes, please feel free to drop any questions into the chat. We'll try to monitor those as we go along. And then the only other thing I wanted to mention is that we do have a pretty dense slide deck on purpose for all the lawyers out there, of course, to be able to take with you. So my understanding is that the PowerPoint will be provided after the program. I understand that it's going to be posted on the website. So check for it there if you want a copy. And then also, yes, hello to everyone out there. I recognize some faces out there, or some names, I should say, and definitely see some privacy pros out there as well, too. So please feel free to drop in with your own comments about things as we go along, because we're all here to learn from each other. So please feel free to do that. All right. So with that, why don't we go ahead and get started then? As Catherine mentioned, this is just a brief overview of what we're going to talk about here today. Obviously, we're here in California, so we're going to focus on California laws. We'll briefly just mention the fact that there are, of course, other comprehensive data privacy laws that look like the CCPA, CPRA, and GDPR. But the focus today is really going to be on California requirements and, of course, the new CPRA. We'll also talk about a little bit with regard to strategies for CPRA compliance, and that's why I'm super excited to have Mallory here, who is a privacy expert at Wells Fargo and is going to provide us her perspective on the in-house side. We're also going to talk a little bit about the new regulator, the California Privacy Protection Agency, the CPPA. For those of you that have been keeping tabs, they've been quite active lately working on regulations. So we'll talk a little bit more about what to expect from them and what they're doing right now. And then we'll close it out just kind of to talk about what to do right now in terms of preparing for the CPRA, and also how to try to stay ahead of all of these changing laws that are very quickly making our lives difficult in some cases, and especially for those of you that have global compliance programs. All right, so just to kind of kick us off a little bit, for those of us that don't necessarily deal with privacy and data security laws on an everyday basis, I just wanted to set the stage for what we're talking about here today by just discussing what privacy and data security laws really are and why it should matter to you as a company. First, we generally talk about privacy and security laws as anything that really deals with personal information. A lot of times it's consumer information, but it doesn't have to be. It can be other types of personal information as well, too. The use of that information, which includes the regulation of it, storage of it, sale of it, protection of it. The way I generally like to think about these laws is that they really regulate all of the data life cycle. So think about a piece of data coming into the organization, its use and storage throughout the time that it's in the organization, all the way up to the point where you decide if you're going to keep it indefinitely or you're going to destroy it at some point in time. that's the life cycle, and really privacy and data security laws touch on all aspects of the life cycle of a piece of data. From my perspective, sitting here as outside counsel generally, I do see certainly a change with respect to privacy laws and the importance that they have taken within companies. It is something that's talked about now at a much higher level within the organization, because there's a lot more attention being paid by everybody, right? Consumers, media, regulators, everybody is paying attention to this as this sort of comes into the limelight a little bit, thanks to scandals that have been had by companies like Facebook that have really brought data privacy practices into the limelight. So from a company perspective, I think it is obviously important to comply with laws, but I think also consumers are looking at and looking for companies who are using their information responsibly. So being able to demonstrate that commitment to privacy, I think, is something that can help companies to do that. And then I'll let Mallory, if you want to jump in here and kind of talk about anything on this slide, I will invite you to do so.
Yeah, and as I'm on the privacy legal team at Wells Fargo, I'll just add, the usual caveat that the views I'm expressing here today are my own. They're not necessarily the views of Wells Fargo or any Wells Fargo affiliates. But that being said, as Elaine was sort of saying, and Wells Fargo is a really large company. Obviously, as a bank, we collect a lot of financial data, but I think it doesn't matter what company, what size of a company you are these days, and it's just with every advance in technology, with everyone, I think the reason that these laws are becoming so so much more important, it just everyone is collecting so much more data, and it's and then the risks that come up for a company in terms of compliance, and the risks to consumers of breaches that we've seen just become greater. So that's why it's so important to see where these things are going.
Yes, thank you. All right. So just to give just a general overview and kind of backdrop, there have been a lot of developments in privacy and data security over the last couple of years. It's just been tremendous how quickly things have been changing in this space. I think that technology changes very, very quickly, and it's hard to keep up with that. And certainly I think the laws are trying to do that, may not necessarily be keeping up, but we're seeing a lot more change in this area than we are in other areas of the law. So just with respect to kind of some of the things that have happened recently, as I mentioned at the outset, we've seen, obviously, California is not the only state out there now with its own comprehensive privacy law. So we have now a few more. Virginia, Colorado, Utah, and Connecticut very recently just jumped on the bandwagon as well too. As a quick touch on those, a lot of them do look similar to the CCPA, CPRA. There are definitely some unique differences between each one of them. So one of the things that we often talk about, I think, in data privacy compliance is creating a privacy program that you don't necessarily have to make a tweak on every time a new law comes around. And I think we're really kind of seeing that come to fruition now with respect to how many new laws are coming about. So we do pay attention to what is coming on out there within the United States and whether or not we'll someday see a federal data privacy law. There's been a lot of talk about that over the years, and each year that goes by, there seems to be more and more desire and drive to have a federal privacy law. We don't have that yet. The US, it does deal with their privacy laws in a very patchwork basis, if you will. So they tend to be sectoral. Depending upon what industry you're in, you may see more regulation around the privacy space, certainly as Mallory does, or if you're in the healthcare space. So we will anticipate that at some point we likely will see a federal data privacy law, but it's hard to say exactly when. Some of the other things that are happening right now we're seeing a lot of, I think, development in biometric information bills. So if you're collecting biometric information, so facial scans, iris and retina scans, fingerprints, if you're using those types of that type of information to identify, verify individuals, we're seeing a lot more development there. I think partially because of the fact that it's becoming much more rampant, and also that it's very hard to change your biometric data. So once that information is collected, if something happens to it, it gets out there It's not like a credit card where you can get a new credit card. So a lot more recognition that that type of information is and should be more highly regulated. And then just very briefly, obviously, the US is one player in a very large scope of laws internationally that are going on in this space. One of the things to pay attention to if you are dealing with Europeans is that there are obviously new standard contractual clauses, which is the way that companies transfer data across state lines. And that there is also, with regard to the UK, they've adopted their new standard contractual clauses, an addendum and a separate standalone clause. So those are things to pay attention to if you are transferring data across borders. And then the rest of it was just kind of hot topics that are going on that I've noticed. Children's privacy is a big one right now with respect to the age appropriate design code in the UK that has now, at least is pending through the California legislature right now, a similar bill with some pretty significant differences. That's kind of what we're seeing there. Mallory?
Yeah, I mean, I think, your mileage may vary as far as the impact of these laws and the international laws. It's really, it tends to be very frustrating. We've had this frustration as in the privacy world for a long time with the data breach laws. It's the patchwork of around the country, just these slightly different laws with slightly different regulations. We're seeing the same thing with these new privacy laws. Thankfully, at least, as Elaine said, we can, there is a good amount of in terms of complying with the laws. There's we can build on what we've done with the CCPA as we go to some of the other laws, but they all have small differences. And then, as far as the federal privacy laws, she said, would be in a lot of ways looking forward to have, it would be nice to have something that would be more sort of blanket the entire country, but the shape that it may take and any sort of preemption, or if there would be any preemption of laws, of the state laws, there's a lot of unknowns if anything like that ever came to pass. So a lot to think about and a lot to, again, depending on the scope of your business, in terms of whether it's international or focusing on California consumers.
Right. Yeah. And that's a really good point. I think we'll talk a little bit more about this later, but obviously knowing what laws you're subject to by understanding what information you're collecting is really important. So really good point there. Okay, so let's dive into talking about what we're here for today, which is the CPRA and CCPA. With respect to where we are today, California does like to think of itself as a leader in this space. We were the first state to have its own data breach notification law. And as Mallory mentioned, we now have 50 different state data breach notification laws that companies need to comply with if they have a large incident. We were also the first state to have a comprehensive consumer data privacy law. That, of course, was the CCPA. And then in November of 2020, we, as California voters, voted to amend the CCPA, and that's what we have now, which is the CPRA. So as we sit here today in May of 2022, the CCPA is still the law of the land here in California. So we're still following the CCPA. And the CPRA, the majority of it will go into effect in January of 2023. So there are some narrow provisions of the CPRA that are effective right now, which we'll talk about in terms of the B2B and the HR exemptions a little bit later. And then, of course, because California is a leader, as we mentioned before, we're seeing other states following up with their own laws now. And I think that there are many, many others on the books there. So be aware of the fact that there's the few that have been passed already and will go into effect in 2023 and potentially more on the way. All right, so just to talk a little bit more about the CPRA itself. As I mentioned, it is a law that amends the current law on the books, but it does amend it quite substantially. The effective date of it is January 1, 2023, but it won't be enforced until July 1, 2023. There's been some discussion. I know some people have talked about the fact that because we don't have things like the regulations out at this point, whether or not there will be a pushback of that enforcement date. It's possible, but at this point, I think we have to assume that it will be enforced starting July 1, 2023. Of course, we talked about the same thing with respect to the CCPA when that went into effect, and there was a lot of discussion and a lot of pushed by some companies to try to convince the Attorney General's office to push back enforcement on that due to some delays in seeing some of the regulations. But ultimately, they went forward with enforcement when they said they were going to, and I think we have to, at least at this point, anticipate that we'll see the same here. There is a look back period similar to the CCPA. So with regard to information that is being collected right now, as of January 1, 2023, if you were to receive a consumer access request or a request to delete, your obligations would look back into this time period that we're in now, and you would need to respond with respect to the information in this time period. So though we are not yet quite effective on the date of the CPRA, it is important that you do have and start putting into place those processes, and if you have not already done that, in order to be able to capture the information that's being collected right now. And then, as I mentioned, we are anticipating regulations. It's the new California regulator, the CPPA, that we will see the regulations come from. They are working diligently on those, from what I understand. We had expected that they might come earlier this year. Initial discussions at some point last year around this time was that we might see draft regulations by the beginning of 2022. That didn't happen. And I guess not surprisingly, they are standing up a brand new government agency. So have a lot of things to get their hands around, including the fact that the CPRA has tasked them with conducting and providing a lot of regulations, a lot more than what we saw in the CCPA. CPRA provides for the fact that there could be regulations on 22 different topic areas within the CPRA. So that's a lot of potential guidance that we could see with respect to implementation, given the fact that these laws are still relatively new. The guidance, I think, is tremendously helpful from a perspective of understanding what the business's obligations are with respect to the different sections that may impact them. There are, and this slide is meant to just kind of highlight some of the bigger differences. And our next couple of slides will talk, we'll be providing at least in terms of a comparison between the CCPA and CPRA. So just wanted to highlight some of these now, and we'll go into them a little bit more in depth as we go along. But there is now a modified definition of what a covered business is. So if you're one of those businesses that was on the cusp of whether or not the CCPA would apply to you, you can look to the definition of what a covered business is and see if it still applies to you as of January 2023. However, I will note, just as kind of a side note here, this is the direction of the law. So whether or not you are subject to the law right now, you can certainly anticipate that the laws are changing to be similarly aligned with the CCPA and the CPRA. And I often tell my clients that anything that a company does with respect to compliance with data privacy laws is usually not a wasted effort. There are a lot of ways that businesses can become subject to liability for misuse of personal information. It doesn't necessarily have to be the CCPA. The CCPA certainly has made it easier for companies to become liable for misuse of data, but it's not the only way, and certainly shouldn't be something that is ignored in my view. Mallory, I don't know if you have any thoughts on that as well.
Yeah, no, I think this is a good overview. I didn't have anything to add here.
Okay. And so just kind of going on, one of the big changes is with respect to the new category of personal information. So the CCPA, for those of you know, sets out 11 different categories. Often privacy policies follow their disclosures along those 11 categories. And with the CPRA, we now have what the CPRA has termed the sensitive personal information categories. That didn't exist as a separate category in the CCPA. Certainly sensitive personal information was regulated, but now it's specifically called out. And in my view, I think probably impacts companies' breach management and preparedness the most, in my view, because now there are certainly potentially additional liabilities that revolve around sensitive personal information, and certainly the expectation being that the more sensitive the information is, the more protection it should have around it. The CPRA also expands consumer rights. So there is an added right to correction, and also modifies the opt-out, opt-in slightly so that there is, in addition to disclosures around the selling of information, which some of you may recall was quite the discussion as to what exactly a sale is under the CCPA. Now we've added onto that a requirement with regard to opt-in and opt-out disclosures for sharing of information. And we'll talk a little bit more about that and what that means as we go along. But it is a much more narrow definition of the term share than you're probably thinking of. It's not simply just sharing data with third parties, but for a specific purpose in terms of retargeting behavioral advertising. All right, it does also, one of the things that the CPRA does, I think, is align itself more with the GDPR. It brings in concepts that are in the GDPR, such as data minimization, which is really basically just collecting only the information that you need and not collecting everything under the sun just because you can and you want to, and keeping it forever as well too. So what the CPRA does now, I think, is essentially have companies ask themselves the question as to whether or not they need the information that they are collecting. And if they do, how long they need it for their business purposes, as opposed to thinking about it in a way of, oh, well, we'll just see what we can do with this information 10 years down the line. Under the CPRA, companies are going to be expected to have justification as to why they're keeping the information for as long as they are. And then in my view, the other big kind of thing that the CPRA brings about is this requirement for certain businesses to conduct annual cybersecurity audits or regular risk assessments, depending upon the type of information that they are processing and the impact that that might have to consumers. There is, like I said, the regulations are going to touch on many different topics. This is going to be one of them, and this is going to be one of the areas where I expect we'll see a lot of guidance in terms of how to comply with this requirement, because it's really not very clear in my view at this point in time. There are a lot of questions around what this is going to mean in terms of what type of security audits are going to be expected, whether or not existing audits and frameworks will be acceptable to the new agency if they have to be submitted to them. So we'll see, I think, a little bit of guidance around this that will certainly clarify what the obligations are for businesses under here. All right, I think one of the things that we talk about quite often with the CCPA is the private right of action. I think that most people know by now that there is a limited private right of action under the CCPA, and that's essentially for what we've described here as the unauthorized access, theft, or disclosure of non-encrypted information, and that loss basically of that data being due to the company failing to have reasonable security practices and procedures to protect that information. So where that occurs, there is that limited private right of action that essentially makes it easier for consumers to bring a lawsuit against a company for having suffered a loss. Now with the CPRA, that is going to be extended slightly, and it's now going to include the compromise of a consumer's email address along with the information to access that. So a question or a password. This, I think, in my view, is an expansion, it's a pretty decent expansion because of the fact that when we think about what's subject to the private right of action and the laws there, it is limited to what we typically think of in the sort of the data breach context with regard to social security numbers and information that might be used to steal somebody's identity, right? So not in every situation are you going to have a requirement to notify consumers of loss of their data. And the same way with the CCPA, not in every situation is every data loss going to be subject to this private right of action. With this expansion, there is a lot more companies in my experience that collect this type of information, right? The email address and the password that would allow access to that account. While maybe not a lot of companies collect, or I should say some consumer-facing companies may not collect things like social security numbers or even credit cards these days, a lot of them do collect this type of information with respect to the email address and password. So now that type of loss may be subject to a CPRA private right of action in that sense as well too. And with regard to the ability to cure, that's something that I think a lot of companies hung their hat on in terms of maybe not having a perfect compliance program, that there was this opportunity to cure it. It was certainly used by a lot of companies during the era of CCPA, which we're still in. But most of the investigations that the AG's office have done have stayed confidential, because in their view, those companies cured whatever deficiencies were alleged by the AG's office. And so those investigations did not become public. Under the CPRA, that technically goes away. So they have eliminated that 30-day cure period. So a violation that's identified by the new regulatory agency or the AG's office, who can still enforce this law, we may not necessarily see an opportunity to cure, and you may see fines being issued outright. Whether or not the CPPA chooses to do that, I think remains to be seen. This area has been a lot of times more about helping companies comply as opposed to sort of the punitive aspects that a lot of times I think you see from regulatory agencies. There's been a lot more understanding, if I can use that phrase, of the fact that these are new laws. Companies are still trying to figure out how to comply with them. So really, I think in terms of seeing maybe egregious violations, maybe perhaps you'll see some fines right away. But there has been a lot of leeway in terms of being able to get to a point where we all reach consensus as to what all these different provisions mean within the law. So I think it remains to be seen whether or not how the CCPA or CPPA will act when it comes to enforcing these laws against companies. Mallory, anything that you want to add to that from your perspective?
Yeah, I mean, I think, as you said, we're all watching and waiting to see where things are going to go. I mean, from the regulation perspective, there's still a lot that is sort of to be filled in, and then this regulatory is sort of the approach in terms of enforcement, both as to the cure and then and how sort of how quickly the agency or the AG are going to be going after companies, and sort of what they will be doing there, and then also just again in terms of the regulations and what they're looking at for like on the data retention, what is no longer than necessary, how are they going to perceive that, how are they going to assess that? So I mean there are a lot of the CPPA has some very smart people working on these issues. They've been seeking a lot of advice from companies and other privacy leaders to give sort of get insight into these areas, and it'll be I think it remains to be seen where things will fall in the next year or two.
Yeah, that's a really good point. I like that you sort of called out the no longer than necessary, what that might mean for data retention, because that's a difficult one. And there's a lot of those types of things within data privacy law where it's very difficult to sort of pin down exactly what that means. And I think some of it obviously is intentional because the CCPA and the CPRA are regulating businesses across the spectrum, right? So this is not sectoral. So basically any business that falls under the threshold requirements that are required for meeting under the law is going to be subject to it. And the businesses are really going to vary across the board as to what they do, size, scope, everything. So having really precise standards for companies to follow, I don't think necessarily will work very well because there needs to be flexibility in these laws. So what is no longer than necessary is going to be really difficult to pin down in regulations. I would anticipate it would be very hard to see the CPPA really talking about what that means in terms of any specific timing of it. But as we go along and as we start to see the CPPA in action and see what they're doing with respect to enforcement, I think we'll start to see some of that get fleshed out. But for purposes of now and what we're talking about now, I do think, and I often say this to a lot of my clients, that data privacy is really about telling a story. We don't necessarily have an area that is a pure check the box where you can just go along and say, okay, I have a privacy policy, I have all these things, I've done this, and now I'm compliant with the CPPA or CCPA. It is more often about what you're doing, that you are thinking about these things, and that you are trying to use data in a way that is compliant. And what that looks like, I think we'll see develop over the next few years. And as we've seen under the GDPR, right, it takes time. It takes time to actually get to the point where investigations are conducted and enforcement actions become public. So, will we see that right away as of July 1, 2023? We'll probably see some things, much like we did right when they started enforcing the CCPA, but it'll certainly take time, I think, before we can figure out where we land on some of these issues.
Yeah, absolutely.
All right, so this is what we were talking about earlier with respect to kind of some of the denser slides in terms of the comparisons between the two of them. So I think we'll go through some of this, but since it's here, if anyone has any questions or wants to talk about some of the main differences, please do jump in with some questions or some comments. As I think most people know by now, the CCPA and of course the CPRA have applications for threshold. So the changes here with respect to the CPRA is that whereas before it was the buy, receive, or sell of 50,000 or more California consumers, which was residents, households, or devices, we're now seeing the buy, sell share of 100,000 or more. And that is with respect to the numbers of people whose information is being collected by the company. And then, of course, we've added in here this selling or sharing term. And with respect to sharing, and I'm just going to touch upon it briefly, I mentioned it at the outset. It is a very narrow definition as to what a share is. And it basically, what it does is expand the CCPA's opt-out and opt-in rights to include this sharing, quote unquote sharing, which is personal information that goes to a third party for cross-context behavioral advertising. That's what's used in the CPRA. And that's essentially interest-based advertising or retargeting. So again, a very narrow definition as to what a share is. And if you are sharing information where you have a do not sell my information button on your website, you may have to add to that do not sell or share my information if you are also sharing that information, and giving consumers an opportunity to opt out of that or opt in if you're under 16. So that's where we're seeing that changes with respect to the application of the CPRA. Exemptions have always been a big one. I think, Mallory, probably you're really well versed in what some of these exemptions might be, and it can speak to it in a much more practical perspective. I'll start by mentioning, of course, the big one that everybody's been talking about is the B2B and the HR exemptions. So those are the parts of the CPRA that are in effect right now that have extended those exemptions up to January 1, 2023, where they are set to sunset. There are, and I think probably a lot of you guys might know, there is legislation that has been pending, but from what I understand and kind of what the boots on the ground in Sacramento are saying, those proposed bills are actually dead in the water right now. They are not going to move forward as they exist right now. California does have this unique sort of ability to gut and amend. So legislatures can take other laws that have died and completely pull out all of the language and text from that law and amend it by replacing it entirely with new legislation on a totally different subject. So there is a possibility still that some type of exemption gets entered in and it becomes law before January of 2023. I think as the days tick by, that becomes less and less likely. So my view of it is to probably make the assumption that these exemptions are indeed going to expire by January 2023. But Mallory, I'd love to hear your thoughts on how you guys are thinking about it right now.
Yeah, I mean, that's basically, I think, and definitely if you're a financial institution as Wells Fargo is, we have we already comply with the Gramm-Leach-Bliley Act. So there's a portion of personal data, consumer data that just is that since we already provide a lot of protections under GLBA, then that data is not subject to the CCPA or CPRA, and that and the sort of the PHI, the health data, which is subject to HIPAA, and certain others. Those exemptions haven't changed, but definitely the B2B and HR ones. I agree, Elaine. I think it's really, we and other businesses, from what I understand, looking to have to for those, I think they're going to be going away. It doesn't seem, for various reasons, both political and this and statutory, just based on the language of CPRA and the privacy protections that are written into it. It's going to be very hard for those exemptions to stay in. So definitely think that we'll need to be planning to have that data not exempted any longer.
Yeah. And so just because I think we didn't say this at the outset, but essentially what that means is if these exemptions expire, then data that has been exempted, which was data that was used for HR purposes only, right? So information that was used to pay your employees and things like that. And then B2B information being generally like the contact information for some of your vendors or your business contacts. All of those will now become subject to the rights that other consumers have under the CPRA. There were some parts of that may not have applied fully, but now you can expect those B2B, the B2B data and the HR data to likely have the same rights that consumers may have. So what that means in practice, I think, is going to be really interesting. This is something that one of my colleagues here, one of the employment lawyers at my office, and I did a podcast on recently as to what that might look like if we actually had to deal with HR data under the CPRA. And interestingly enough, obviously in California, a lot of labor laws already exist that give employees rights in certain areas anyway. So we'll see what kind of that looks like as we go along, but there are a lot of interesting questions about how that applies, because initially the laws were not drafted with that in mind. What that means applying to the HR data, I think we're gonna see some questions pop up in terms of how to apply that correctly. Okay. I think there was a question really quickly. It's a little bit kind of within what we're talking about. So I'll go ahead and read the question for those of you that can't see the chat. And the question is whether or not there's any further guidance from California about de-identification. For example, what standards businesses can look to for de-identification. So I haven't really seen anything lately. I do anticipate that one of the things that the CPPA may do is discuss that and discuss what may be considered de-identification. So perhaps more guidance when we see the regulations come forth. We do kind of talk about de-identification from a statistical standpoint quite often, as opposed to sort of just hashing. But Mallory, any thoughts on that you might have?
Yeah, I mean, same. I think, I think it's definitely someplace where we're going to have to look to the regulations and further guidance. I mean, maybe, there's, as usual, the EU is ahead of us there with and GDPR and anonymization and pseudonymization. So I think there's some guidance there and some that we may be able to look to, and that the CPPA may be looking to, but nothing concrete as recently.
Yeah, and that's what I've seen as well too. The comments that I've seen that have been submitted to the CPPA with regard to this topic have been largely revolving around the GDPR and asking them to look to the guidance that has come out from the GDPR already. So we'll see certainly some of the concepts that they've adopted there make a little bit more sense than what we've done here so far. But yeah, I think we'll see probably more guidance from the regulators that come out later this year. And then, with regard to timing, I think I asked this of anybody that I get a chance to, but if anybody has any information on that, we're going to see an update from the CPPA. I'll just mention this now since we're talking about it. They have scheduled a public hearing for May 26th, where they will be providing some updates at that meeting as to hopefully when we might see some draft regulations. I'm sure they won't give an exact date probably, but maybe hopefully a timeline of when we will. I know a lot of my clients are concerned about being able to get the regulations, understand them and implement them before January 1 of 2023. And kind of my view of it is along the lines of, okay, well, again, data privacy is about telling a story. So if we are thinking about what we're needing to do, we're working on that implementation. As far as enforcement goes, obviously it doesn't start till July of 2023 anyways, though companies are going to be expected to be in compliance by January 1 of 2023. My view of it is in this space where we will see some leeway in terms of what likely happens in the enforcement realm on that front, given where we are right now. But that's kind of my view of it. Mallory, I don't know if you see it differently than I do.
No, I mean, I think it will be interesting to see what they say on, how much we learn on Thursday when they do this update. The CPPA has definitely been taking a very, it seems like a very thoughtful approach, which is good. They've been seeking a lot of input from privacy, attorneys and companies and everything. On the other hand, because there are so many areas that are, still need to be spelled out in the regulations, just as the CPRA leaves it open. So it just, while there's just a lot, it's good. There's a lot of, they're getting a lot of input, and it's just, I think it's going to be, it will be interesting and tough to fold that into regulations in a sort of very timely fashion. So it'll be interesting to see how that goes, what they say.
Yeah, and Mallory, are you guys kind of taking a wait and see approach? Are you guys making some adjustments now, waiting to see what some of those regulations look like, or what are you guys doing?
I mean, again, I can't speak specifically, for confidentiality, reasons, but what I've been talking with colleagues and others in sort of financial industry about, I think, we're all already complying with CCPA. I think there's a lot of, they're sort of not able to really wait and see because of because of the timeline. I think what I and others have been trying to do is just see what, do as much as we can with what's already, set forth, and sort of, not reading the tea leaves too much, because there's enough, I think there's enough to do with, some of the things that are already, like, the new data access rights, certain things like the corrections, and updating where we can. It's definitely, I don't think as much as it would be nice to wait, I think there's a lot to be done. So trying to get moving.
Yeah, and we'll talk a little bit more about that as we go along here too, when we get to our tips to stay ahead of things. So, okay, great. All right. And just one of the other things that we had started to touch on earlier that I wanted to mention with respect to this slide is the new category, the sensitive data. So sensitive data is those things that you would expect, like social security number, driver's license, but it also includes obviously biometric location, precise geolocation, which I think we'll see some guidance from the regulator as to what exactly precise geolocation is, as well as things like racial and ethnic origin. So those types of data points may not necessarily have been on some companies' radar with respect to it being sensitive information. Certainly is obviously if you're complying with the GDPR and thinking about it from that perspective, but we tend to collect information such as, racial and ethnic origin a lot more frequently here in the United States than maybe you'd see in other countries. So just wanted to point that out with respect to the collection of that information, there will be new obligations around what you can do with that information and the rights that consumers have around that information. All right, and then moving on, this slide just gives a comparison between some additional points within the CPRA and the CCPA. I think we've mentioned the consumer rights, that there are differences there. So the CPRA obviously gives the same rights under the CCPA and adds the right to correct information. There's always a lot of discussion around this one as well too. What does that mean? What am I going to actually have to correct? What if I think that the information is incorrect? And there will be an opportunity for companies to make those types of decisions about the request and deny the request on the basis if they believe reasonably that it's going to cause the information to be incorrect, along with a lot of other things. So, the right to correct, like the right to delete, does have some limitations on that front. Some of the business obligations that we've talked about, in addition to what is under the CCPA required, the data minimization and purpose limitation, I think, is going to be a big one. I know a lot of companies often collect information without worrying about or thinking about why they're collecting it or how long they want to keep that information for. Data retention and destruction programs in some companies I know can be quite robust, and others not so much. So those that don't have data retention policies or programs in place may want to start thinking about that ahead of time. This is one of those things that you can do now and not have to wait, for any guidance from the regulators. Having a data retention program or policy in place is something that, in order to comply with the CPRA, you will want to have in place. The other things, I think one of the things that we can talk about now as well too is with respect to the requirements for the written contracts. For those contracts with third parties where you're sharing personal information, the CPRA does make it a requirement to have specific provisions in place that basically limit the use of that information by that third party. And there are some new terms within the CPRA that have gotten some attention with respect to service providers versus contractor versus third party. The distinctions, in my view, are maybe not as important as some people have made it out to be, but that's just my view, at least at this point. We'll see what happens as we kind of go along here, but that's one of my viewpoints at least. So with respect to enforcement, we mentioned the limited private right of action earlier and the expansion there. The other piece of it also being that enforcement will be both by the Attorney General and by the California Privacy Protection Agency. They are permitted to enforce the law alongside each other. The CPPA has already signaled that it has been working with the AG's office, that they'll likely continue to do that. And they've certainly been taking pages out of the AG's book in terms of how they prepared for the CCPA. So we're seeing a lot of similarities there. So we can, I think, in my view, probably expect to see some similar approaches with respect to enforcement as well. All right. Anything to add to that, Mallory?
I was just going to quickly go back to the data minimization point. I mean, I think, from a in-house perspective, it can require a little bit of a switch in perspective, and it can be a bit difficult between legal and the business. And that, again, and Elaine mentioned earlier, a lot of times it's the view has been, let's just collect as much as we can and keep it and see what we can do with it 10 years down the line. And, I think it's just more and more, not only because of the specific requirement the specific mandate now for data minimization, but just in general, it's going to be a lot easier to comply with all these laws, with less data on hand. So I think it's sort of again, it requires a bit of a switch in perspective and approach, but to the extent that it's, it's sort of something that needs to start happening, just, thinking a bit more, do we actually need this data? Can we do what we need to do and still, have a, work, can the business still do what it needs to do with less data, because it's going to, again, in terms of compliance and everything, the more data you have, the more obligations you're going to have with it.
Yeah, and along that line, right, it reduces your risk profile as well too. So you can't be subject to liability for information that you're not holding. So if you are holding all that data and you lose it, I've seen some really unfortunate situations where data breaches have occurred with respect to legacy data that was just being held, and nothing had been done with that data for, I think at that point, 10 plus years. It could have been 20 years at that point. And it was data that wasn't needed, yet they had a data breach and had to do notification as a result of that because of the loss of that legacy data. So, paying attention to what you have, getting rid of what you don't need, it'll help reduce your risk profile in that sense.
Yeah.
Okay. All right, we are getting up on the last part of this presentation here, so we'll kind of just quickly go through the CPPA. I think we've talked a lot about what they're doing now with respect to the regulations when we might see those. We will just very briefly touch on this then, and just mention, of course, that it is an agency that is dedicated solely to consumer data privacy. That's unique for us. At this point, there hasn't been anything like this in a very long time in California, and it's the first one of its kind in the nation. So I think it's going to be watched quite closely throughout the nation to see what happens with that and what that might look like as they kind of progress forward. One thing that they are responsible for, so they're responsible for essentially the enforcement, rulemaking, which we've talked about, auditing. So there will be audits that will need to be submitted to them, and it's going to be decided as to how involved they will be in the process, I think, with the auditing during the regulations stage, and we'll see that happen. But also with respect to education. And I think that this is actually a pretty important point. They have taken it seems like very seriously, that part of their responsibility is going to be educating the public about their rights under the law with respect to consumer privacy. So I think that there will be, as we march along here, a lot more understanding from the general public as to what their rights are. And that in turn will, in my view, likely lead to more data subject access requests or consumer requests to control their data. So I know in some areas, in some industries, companies are not seeing a lot of requests. And you may start to see an uptick of that as people start to know that they have these rights. So I think that that's important to note. All right. Anything else we should mention with respect to the CPPA?
Yeah, I don't have anything else on this one.
Okay. All right. So then moving on to just talk about, I forgot about this slide. Oh, just with respect to this very briefly then, they are hiring a lot right now. They have an executive director, Ashkan Sultani, who's a very experienced privacy pro. My understanding is that they haven't hired a permanent general counsel yet. I think they have an acting general counsel, but they're looking to staff up right now. So that's what they're doing right now. We did mention that they have that hearing coming up on May 26th, so likely to hear some important updates by that point. So keep track of that. All right. So Mallory, you want to kick us off on this slide?
Yeah, and I saw the question in the chat. I'll address that as part of this. So, I mean, just in terms of compliance with CPRA, as I already sort of indicated in terms of whether we can whether companies can sort of take a wait and see approach, or I think because it builds on the CCPA. It's any compliance, if you're already complying with CCPA, then whatever compliance you're doing with CPRA is just going to build on that. As Elaine mentioned, if previously you were on the bubble of whether the law applied to you, then there will be a bigger lift in terms of sort of getting started if it's now going to apply, or if there's different details. So I think, but either way, there are these different, as we've already discussed on the previous slides, there are different, there are new details. There's the new-ish concept of sharing. Again, it's, not just sharing and not just selling. There's the CCPA already required that companies that are selling personal data have this, have an opt-out button. But now it also applies to if you're sharing data, but it's only, it is a limited scope of sharing, but it is a kind of sharing that a lot of companies were doing that maybe maybe wasn't considered selling, but if they're sharing it for the purposes of this cross-context behavioral advertising, that also is something that has to be disclosed and allowed an opt-out. So that's something that you need to understand whether your company is doing. The whole sensitive data, again, sensitive data was already regulated. It's not like sensitive data wasn't regulated under CCPA, but now it's carved out into a specific category that has, and again, this is an area that is definitely, there's a lot of murkiness in terms of some of the rights that are going to be, or how the scope of the rights for consumers as to their sensitive data. It's but I think understanding what sensitive data your company collects and understanding sort of how much, where it is, and sort of getting a handle on that is a big task. And again, it was already regulated, but it's because of the new rights that are going to be afforded to consumers regarding that data. It's important to get an even better handle on it. And so then, again, we talked about this a little bit, but the expiration of the HR employee and B2B exemptions means that individuals, the employees at companies, employees are going to have the ability to, with regard to their data that was previously they didn't necessarily have, the ability to request access rights or access deletion. Now there's correction, and same with business counterparts. Now they are going to have these rights. I think one thing to be looking out for is that because employees especially are going to have a right to request access to certain information. It could be used in they may be able to request this, and they're going to get access. They'll be able to get access potentially in a way that they might not have, and could be used in sort of pre-litigation scenarios. Which leads me to looking at my thoughts on the question that was asked in the chat regarding retention of emails. I think with the expiration of the HR, expiration of the HR exemption, I think that if a company doesn't already have a strict retention policy regarding emails, I think that it would be prudent to look at one. I wouldn't suggest having emails deleted, every month or something. Obviously, there are plenty of emails that need to be collected, but just again, given the expiration of that exemption, I think it's something that could come up, especially again in pre-litigation scenarios. Elaine, I don't know if you had any other response you wanted to, anything else on that question?
Yeah, no, I think that's good. And I'll note that we are at our time. It's 1 o'clock right now, so we won't be offended if people want to jump off, but we will just go ahead, I think, and close out our last slide, if that's okay. And our last slide, I can move it forward. Just to kind of provide a checklist for everyone out there as to some of the things that you should be thinking about if you're thinking about your CPRA compliance program. Obviously, with respect to a lot of different things to do, like we've talked about before, having an understanding of what data you have and where it's going, where it's being shared, is really helpful in terms of being able to comply with privacy laws. I think it's one of the most important things. It's very difficult to comply with laws like this without having that understanding. And of course, whether or not HR and B2B data should be a part of your data map or inventory. My view of it is likely the answer to that is yes, considering we will probably see these exemptions expire, but you never know what the California legislature is going to do. And I think, Mallory, you've ticked off some of these or mentioned some of these in your last slide that we talked about. and, having an ability to just understand your data, know that you're going to be receiving these potential data access requests. So having an ability to respond to those requests, I think, is really important if you're just thinking about getting your privacy program up and going as well too. And then, I did also want to mention, because this area is very fast changing, it is important to have a way to stay up to date with what's going on. And, I know how I do that in terms of, it's always a morning task for me when I wake up to kind of figure out and understand what things happened overnight in data privacy, because inevitably something has happened that's impacted a portion of my practice. So I do spend quite a bit of time making sure that I stay up to date on what's actually going on out there. Mallory?
Yeah, I'm same. I mean, there's a lot of thankfully a lot of resources, a lot of updates out there now. It's definitely, it's a large task. But staying abreast of what's going on in the legislation in the US and also in the EU and in China, it's important to at least have a glimpse of that.
Yeah. Yep. And then to know and understand that we do have a different regulatory landscape in this space now, I think, than we've ever had before. So especially with our new regulator here, it's really going to be interesting to see what they do in the next couple of years. But I think, being on top of your compliance program by just at least thinking about these issues and thinking about how you're using that data is a really important start. Okay. Thank you very much.
Okay, well, thank you very much, Elaine and Mallory, for that very informative, as thought-provoking and slightly terrifying result come January of 2023. But we are very appreciative of your presentation today. And as we put on the chat, we will have the slides available for everyone. And here's obviously Elaine and Mallory's contact information. So thank you again, ladies. That was fantastic.
Thank you.
Thanks, everyone.